issue to get sorted out. I'll just get us started. My name is Martha Rands. I'm the Director of Programs for the Pacific Legal Education and Outreach Society, and we started this series of webinars to address questions that were coming our way as a result of the COVID-19 pandemic. I'm grateful today to acknowledge that we are offering this workshop, and in fact all of our work, on the unceded ancestral lands of the Squamish, Tsleil-Waututh, and Musqueam peoples, who we thank for their forbearance on our behalf. And without further ado, we will be today talking with Clea Parfitt about the duty to accommodate in light of COVID-19. As many of you may know, or not, Clea is a lawyer in private practice here in Vancouver and has dedicated herself to the matters arising under the Human Rights Code and other things, but primarily human rights issues in a variety of fora. I personally am grateful for her taking time out of her very busy schedule to share with us some thoughts on what we should be watching out for, in particular as we are looking at folks returning to work. And you will notice now the closed captioning button is up, so those of you who need to follow the captions, please do. And for those of you who have come with questions, please put them in the Q&A box section at the bottom. There's an icon Q&A. I will be monitoring after Clea commences her remark, after Clea has finished her opening remarks. So Clea.
Thanks. Thank you very much, everyone. So when we're thinking about nonprofits and human rights, what we're thinking about is the role of nonprofits as employers, as service providers, and in some instances as landlords. Human rights legislation, which in British Columbia is the Human Rights Code, prohibits discrimination. And in particular, it prohibits discrimination in employment in the provision of services and in tenant matters. So then the question is, what is discrimination? Discrimination can occur when a decision or action with negative consequences was made because of a personal characteristic of a person. For example, a person was not hired because they were a woman, or they might become pregnant, or they have a disability, or they're too old, or they're from a particular country or race. Discrimination can also occur, however, when actions or decisions or policies or even the physical setup of a workplace have a particularly negative impact on someone because of their personal characteristics. And that's sometimes the more difficult kind of discrimination to think about and to spot in the moment. And an example of that is, if you only provide access to a building by stairs, that will have a particularly negative consequence for someone who has a physical disability, for example, and cannot climb stairs and requires a ramp. Negative impact of action or policy in this sense can be quite unintentional, and it requires us to think about the consequences of our actions and the way we've organized things for people who have different characteristics. And when we talk about personal characteristics, what are we talking about? We're talking about things like sex, age, disability, family status, for example, having children or elders in the family to care for. We could also be talking about sexual orientation or gender presentation, but those things are not as likely to be at play at the moment in COVID. When we're thinking about personal characteristics, it's really important to recognize that more than one personal characteristic may be at play. We might be talking about a woman who is a single parent of children, who has responsibility for family members, perhaps even overseas, because of their place of origin. So a number of personal characteristics can be operating at one time. When we're talking about the obligation not to discriminate, the question arises, how far does that obligation go? How far does an organization have to go in not discriminating? And the answer is to the point you need to take every step you can to avoid the negative consequences for the person whose characteristics are in play. You need to do everything you can to the point of undue hardship. And this is a high standard. It does sometimes require organizations to encounter some degree of hardship in the steps they have to take to ensure that they're not creating negative consequences for people based on their personal characteristics. This idea of doing everything you can to avoid negative consequences is often described as the duty to accommodate, which is a duty to modify the workplace demands or the way a service is provided to reduce or eliminate the negative consequences related to personal characteristics as much as possible. So we're not always looking for a perfect accommodation, but we're looking for a reasonable accommodation, an accommodation that's as good as it can be. So what impact does human rights have on how we respond to changing circumstances related to COVID? And as Martha pointed out, the likely upcoming return to work that we may even be starting to hear about today from the provincial government. Well, nonprofits as employers, as service providers, and as landlords have the same obligation they ever had not to discriminate. So not to make negative decisions based on personal characteristics, and not to take actions or make decisions or have policies that have particular negative consequences. So the general obligation hasn't changed, but there are now new circumstances because of COVID. So that means that when you're responding to changing circumstances around COVID, you have to keep in mind the personal characteristics of the people you're interacting with. You have to ensure that the decisions that you're making and the things that you're setting in place and the organization that you're proposing is not having a particularly negative impact on people because of their personal characteristics. And that if there is a negative impact, that you're doing everything you can to the point of undue hardship to try and avoid those negative consequences. The duty to avoid discrimination, to limit the harm you're doing, and to take action and accommodate to the point of undue hardship requires, in my view, a practical and common sense approach, especially at this time where everybody's trying to muddle through unprecedented circumstances as well as we can. And that practical and common sense approach is required from you as a nonprofit, but it's also required from the other side, from the employee that you're dealing with or the person who's using your service. So it's a two-way street, but definitely one that has to be initiated by the nonprofit, or as the Human Rights Commission refers to you, as a duty bearer. So how might these requirements play out then in an example that relates to COVID? So let's say you're an employer, your employees are not at work, you want to call your employees back to work, and an employee does not want to come back because they're immunocompromised or they have an at-risk family member. What should you do in that situation? The first thing you probably should do, in fact, whether or not you have a specific issue like that, is to review the WorkSafe instructions for what employers are to do if they're going to have employees in the workplace. And Martha has a page, PLEO has a page where this sort of information will be put up after this session today. But essentially, WorkSafe BC has created a set of instructions for employers to look at questions really to think about before you bring employees back into your workplace. And it has to do with things like where are the issues going to arise, what can you do to mitigate them, extra cleaning, changing your physical setup, maybe changing the way you organize shifts if that's relevant to you. So there's quite a lot of important questions there that help employers to think through issues that might arise as you bring employees back into the workplace. So that would be a first step. Having done that, and assuming that you have a plan in place that generally moderates the risk of COVID in the workplace, for a person with immunocompromise, then my analysis would run something like this. Immunocompromise is a personal characteristic, obviously. In a context of heightened risk of infection, which we have at the moment because of COVID, it's likely that that personal characteristic qualifies as a disability. So you then, as a service provider or as an employer, have an obligation not to make demands or rules on that person that will have an adverse impact on them because of their personal characteristic, which likely amounts to a disability. And similarly, family status, if we were talking about someone who had a family member who was immunocompromised, family status also a personal characteristic. The need to take care of vulnerable family members would again mean that the nonprofit has an obligation not to make demands or rules that will have an adverse impact on that person. So you need to consider all your circumstances when you're looking for a practical solution. What is the person's work? Can they effectively do it remotely or continue to do it remotely? Are they willing to do it remotely? Is there some way of altering their job duties or limiting their job duties, or perhaps bringing in different job duties that weren't originally part of their job that you could do in the interim to allow them to continue to do productive work for you, but not necessarily have to return? Alternately, is there a way for them to come into the workplace which would significantly limit whatever exposure they would have? Can they work a different set of hours than other people are working? Can they work in a part of the office that other people aren't visiting? So I think you have to engage in a very pragmatic exploration of how can we meet this person's needs and yet have them doing productive work. If the person is on layoff, you might decide to extend the layoff. It's important to recognize that layoff can only be done by agreement, so you can't do that unilaterally. If you lay someone off unilaterally, they can consider themselves dismissed or terminated, and then you may have some liability arising out of that. If a way of working cannot be found, then you might consider their position that they can't return to be a request for medical leave, and you might then grant a sort of indefinite leave as a medical leave. The question then arises, what documentation would you require? I think it seems like the standard at this time is that you can ask for some sort of documentation or some sort of information to satisfy that yourself that there is a real need, but you shouldn't be asking for doctor's notes at this point because they're very difficult to get. If you deal with it via medical leave, of course, or a layoff, the person may not have ongoing money coming in, and so that's likely to be an issue for them. And I should note that the Employment Standards Act has new rules about leave, and I'll come back to that, but there's a whole bunch of circumstances where if someone's taking a leave, you must leave the job open for their return. And I would say in general terms, even if they didn't formally qualify under the terms of the Employment Standards Act as they've been changed, you nonetheless would want to leave the person's job open. So if someone takes a leave or continues a layoff, you shouldn't fill their job permanently with someone else. You should make sure that they're in a position to come back when circumstances change, which hopefully they will eventually at least. Whatever you decide with the employee, it's really important to document the conversation that you have around how to accommodate their need not to come back. What you're looking for is a solution that everybody can live with. And once you have that solution, you should document that solution. When I say document, I mean put it in writing. I think you want to be as creative and flexible as you can be. And if you want to avoid a human rights complaint, what you want to avoid is a situation where the employee feels they have to quit to protect themselves, or that they had to return to work and face a health risk rather than lose their job. I don't think you want to put people in either of those situations, because those are situations where you might face a human rights complaint. So we're talking about a situation where you need to do everything you can to avoid being doctrinaire, and that is the essence of a human rights lens, or the human rights solution, is that one size does not fit all. You're going to need to tailor your approach to ensure that people are not having to carry an undue burden or take undue risk because of their personal characteristics. When we're thinking about someone returning to work, maybe with a different bundle of tasks, or maybe not doing all of what they used to do, I should note that human rights law accepts that some reduction in output is not an undue hardship for an employer, and that pay then would continue as normal. By contrast, a very substantial reduction in output might be considered an undue hardship and might then justify a reduction in pay. I think there's going to be more flexibility around that in relation to COVID than there might have been at other times. And an inability to work at all means that a leave is perhaps valid or should be granted, but it doesn't mean that pay has to continue. As it's clear in the law at the moment that if you're not able to work, you're not required to continue paying an employee. And that has been considered an undue hardship. And I think that the question about productivity might be particularly, you might be required to be particularly flexible if you've received some kind of wage subsidy, so that the harm to you as an employer is moderated by the fact that some of the wages are being paid by the federal or provincial governments. So I have some other scenarios, Martha, but are there some questions now from the group that might be tackling?
Yes, there are. So,
okay.
So very clear question. Would it be appropriate to get a doctor's clearance with specific recommendations for accommodation for someone who is immunocompromised?
It seems at the moment that you can't ask for a doctor's note. If they have access to a doctor's note, I mean, that might be something that you would explore. It is a practice in getting people back to work who require accommodations to ask doctors to say what they need. I'm not sure to what degree a doctor is going to be of assistance, but it may be that if the person has access to a doctor and you've worked out, or you have some suggestions, you might send those to the doctor. I think it might be a bit tricky at this point and it might not be very time sensitive at this point to cede to a doctor the duty of trying to figure out how to change your workplace. It might make more sense to say, if we did this and this and this and this, would that reduce their risk? It's not completely clear to me that a regular GP would have that information. I mean, the question about what set of circumstances creates risk of infection is probably public. So I'm just going to try and turn my phone off here. Sorry, we're just going to have to let it ring because I can't remember how to mute it. My apologies. It's really a public health question about how, in general, the virus is spread. I'm not sure a GP is going to be able to answer that. So it is important, if you think you can readily get some input from the GP, that's great. But if that's going to become an impediment to having the person return, I would issue caution. I think it's most important to try and get the person either in a situation where they don't have to return, or if they're comfortable returning. I think ideally you won't return an immunocompromised person. Is probably how that will work out.
Right. So a related question is, if we are unable to ask for a doctor's note, what documentation would someone be able to provide to show that they have a health concern that restricts them from coming back to work?
Yeah, so while normally what an employee is required to tell you about their limitations and not necessarily why they have those limitations, if they're not able to get a doctor's note, which they may well not be able to, they may have other documentation, that indicates, they may have prior information that they've received from their doctor, or they may simply have to tell you, this is the condition that I have, and that condition results in being immunocompromised. So I think it might be fair I think the standard appears to be something that's reasonably convincing, but not necessarily a doctor's note. And it may be that, you have to err on the side of caution by accepting their statement about their situation. rather than take the risk of putting them in a position where they need documentation they can't get and they're not able to return without it.
Yeah, so one example that came to my mind when I was thinking about it there was somebody who has kidney disease. That has never come up as a workplace issue before, but very definitely would now, because people with kidney disease are at increased risk for serious complications as a consequence of COVID infection. I would think that if they were, and such people, first of all, they're going to have some medical records possibly, but if they didn't, they would definitely be under medication, taking medication for the condition that would indicate that they, in fact, that this medication was for kidney disease, like such that they could maybe go to the pharmacy and get the printout of what the medication is for. That would be one way, it seems to me, of substantiating if you really feel you have to get that. And I would suggest perhaps that's overkill, but in the event
there's also a ton of good information online about what medications are for. So actually asking about the medication someone's taking is a good idea, because you know, essentially you can find out what any medication is for now online. So you wouldn't need to go to the pharmacy for that. But yes, I think asking, you know, whereas normally as an employer, you might not be entitled to ask what their actual condition was. If they're not able to provide a doctor's note, then asking them a bit more information about it, and, you know, saying, you know, what medication are you taking, would allow you then to confirm the sort of the truth of that. And, you know, we're not talking about hopefully an endless situation. And so the risk then for the employer is less, and the standard that needs to be met by the employee probably correspondingly less.
Right. So another question has been asked whether it would make a difference. This is in the case of somebody who lives with someone who is immunocompromised. Would it matter if they're a family member or a roommate? Would the category of person, their relationship to the worker, would that make a difference in the calculation of?
That's an interesting question, because the Human Rights Code doesn't operate in a blanket way. It operates in certain defined circumstances. If it's a family member and you're taking particular care of them, you know, clearly family status would help you in that instance. If it's a roommate, interesting question whether you've got a personal characteristic that you can rely on under the code. And the answer might be that you don't, because it's doubtful. I'd have to go back and look at the language of the tenancy protections, but it's doubtful that that would operate here. So you might have, it might be more difficult for the individual to argue that if you didn't take account of their needs as a person, you know, rooming with an immunocompromised person. But I think nonetheless, as an employer, you would want to accommodate that. I mean, I think that you know, you also need to be thinking about what the health orders are and so forth. And clearly that there aren't orders around immunocompromised people, but there's definitely guidelines with respect to that. So I think you would want to accommodate that, but it's true that you might not be legally obliged to.
Interesting.
Yeah, interesting about that.
So as a follow-up to the question about being immunocompromised, do you know of any guidance on what kinds of accommodation are appropriate for immunocompromised people? Yeah, I mean, I think I don't, in terms of specific guidance, I mean, I think starting with the WorkSafe indicators about how to make your entire workplace as good as possible. I think then extending that so that, you know, can you get to a place where there's very little, you know, there's no risk of interaction with the public, where there's very little interaction with coworkers, where
their particular area of the workplace could be kept, particularly clean. Are there, I don't, but is there, am I aware of a particular source of that information? No, I don't know where that would be.
Yeah, I mean, the WorkSafe guidelines go into significant detail.
They do, they really do.
Yeah, about the requirements for physical distancing, for example, as well as protocols around cleaning and what circumstances apply. They also are available for employers to consult with about how to do exactly that. And, if you can't, the question I think that does arise is, how do you deal with that one employee who is simply unwilling to return, period? And I think that underlies there are going to be people who are prepared to go back into the workplace and work with make sure within physical distancing guidance. Then there are going to be some that are going to say, I'm panic stricken, anxiety ridden, and I won't go back. And
if the person is developed, it's undoubtedly the case that the COVID pandemic has sparked serious anxiety in some, members of the workforce. And anxiety itself then might become a disability. And so whereas the underlying condition might be that they're immunocompromised, their reaction to that might itself be a reactive anxiety. And so, I think there's a need for employers to be relatively gentle at this time. I think, my expectation is that the Human Rights Tribunal, when they're faced with these complaints in 2 years' time or whenever they actually show up on their desk, are not going to look kindly on an employer that was not, where we've had everyone out of the workplace for months. They're not going to look that kindly on an employer who can't make an arrangement with an individual employee that everybody can live with. And, if the person doesn't, I don't think it's reasonable to force someone to come back or to put them in a position where they're quitting because they're not willing to come back and you're not willing to not have them come back. And particularly since, if they request a leave, then it's appropriate to try and accommodate that leave. And unless you've got a tiny workforce, you're going to have a tough time convincing the tribunal that you could not grant a leave in this situation. So, I don't think that getting into some doctrinaire battle with an employee is going to serve an employer down the road.
Yeah. So somebody also has immediately picked up on the obvious problem of saying, I would think that someone would refuse to provide information about the medication that they're taking for privacy reasons, and what could be done in that situation.
Well, an employee does have an obligation to provide information, the necessary information to substantiate, to establish an obligation to accommodate. Normally, what would be required or would be legitimate to request is a doctor's note. In a situation where the advantage of a doctor's note is all it needs to say is the person has this limitation, doesn't need to say why, doesn't need to tell you any details. In the absence of a doctor's note, if the person doesn't think they can get one, and I think increasingly that won't be the case as doctors start to figure out how to provide their services remotely, you'll be able to get a doctor's note. But at the moment where it is difficult and where people are being told to stay away from their doctors, then some flexibility on both sides is necessary. You as the nonprofit are going to need less proof. They may have to provide more information. And so, when you're requesting something of your employer, privacy gives way at that point. And you're essentially, your employer's not demanding that information, you're offering it because otherwise your employer won't have an obligation to accommodate you. Right. And so I think that's, as an employee, you make the choice. Maybe I don't want to share that information, but then I may not get the accommodation I want, or I may have to, go through quite a bit of hoop jumping to get a doctor's note so I don't have to provide that information. And, I acknowledge that there are workplaces where employees do not want to provide any kind of information because they don't feel comfortable with how it'll be used. And, that'll be a problem.
Yeah. I do want to point out that in some cases, like there is, one could say, I am an insulin dependent diabetic, for example. if there was a, a particular, and we can show this in some fashion, usually it's very straightforward. There's also no requirement on the employer to religiously hold on to every single piece of paper that the employee provided. That is to say, if there was multiple medications that were connected to the kidney disease example, that, having accepted their assertion at this stage right now, I don't know that you would keep the information necessarily forever, so I would encourage you to also think about being creative around what would substantiate. And once having substantiated it, when the person is able to get into their doctor, they can get a doctor's note. But in the meantime, if you feel you need additional information, then you can reassure them that you're not going to start collecting X or Y amount of information.
And I think you've struck on another approach that could be taken, which is, okay, my employee tells me they have kidney disease. I'm not going to require them to provide me with a medical note now, but I'm going to say to them, I'm accepting that. And, when things are open again, I'm going to ask you for a medical note at that time. So it puts them a bit on notice that if it's completely made up, there'll be a problem. And, it isn't my sense that people are going to claim to have diabetes or kidney disease or immunocompromised in order to avoid returning to work, because the consequence of not returning to work is they might not get paid. And, that may not be that workable for them.
Yeah. What if so another question relating to the taking care of family members. What if you are not taking care of family member who is immunocompromised, just that they are immunocompromised themselves and live in the home? This is a continuation, I think, of the roommate issue. Is it merely the fact that they live in the home with an immunocompromised family member, therefore you need to accommodate the employee?
Yes, I don't think it matters if you're caring for them, because I think COVID doesn't care if you're caring. It's just a proximity. It's just a factor of proximity. And so, it may depend on how severely immunocompromised the person is. And, perhaps because some of the things that they can do, obviously they can take particular care as they return from a workplace. It's not necessarily the case that the only way to keep a roommate or a family member safe is not to return to work. It probably depends how severely immunocompromised the family member is and how great the risk in the workplace is. Because the risk in the workplace, if you have 3 employees, might be very low. If you have 40 employees and you're working in a tiny space and you have a ton of public contact, it might be quite high. And so, the circumstances, I think, are going to be relevant. And it may be that WorkSafe, can be drawn upon at that point to provide some further guidance. It may be that we end up using WorkSafe to assist us with some of these really prickly questions in a way that we probably haven't been used to using them in the past.
Yeah, I mean, it seems to me that in situations where you really want backup, and especially where it's going to really matter for the society to have these people come back to work, calling WorkSafe, or on the other end, for the employees to call WorkSafe and say, I really feel uncomfortable about this and we need help. Now, the question there is going to be, how many people are going to have quick access? I mean, how long will it take for them to respond? How readily will they do so? Will they try to do it all by telephone, and that we don't know, I don't think.
No, I mean, I haven't encountered a situation yet where WorkSafe has come in, except in the news. I mean, I know they've been involved in some of the poultry places that have been closed. They've been in there saying to them, okay, here's what you need to change about your physical setup. And there are orders that they must comply with before they can reopen. So WorkSafe can, normally operates in that way through making orders that have to be complied with. But I think that they can, their training is to go into workplaces and provide practical solutions about how to moderate risk in the workplace. So that is something they're particularly geared up to do. But you're right, I don't know how deep that resource is going to be. And again, I think that, you know, the key message is be flexible, try not to press your employees into a place where they're, you know, they're having to quit or you're terminating them because they won't return. I think that's, you know, you want to avoid that because you will be facing human rights complaints otherwise.
Yeah. And this is picking up on that thought is the person who doesn't want to return to work or is uncomfortable coming into work for whatever reason, and not based on a protected ground that we would have a duty to accommodate. How do we effectively get them back to work and avoid a human rights case?
Well, if they don't have a personal characteristic that's at play, they don't have a viable human rights complaint. So that person is a human resources problem, but maybe not a human rights problem. You know, ultimately you decide, I mean, you know, I think exploring what people's anxieties are, attempting to, you know, meet those anxieties, talking about, you know, thinking about through yourself carefully about whether there's a way for them to continue to work remotely. But ultimately, you know, if an employee refuses to work and they don't have a justifiable explanation, then you may have to terminate that employee. But if they don't have a personal characteristic that's in play, the risk is less. I mean, a refusal to work is a basic for-cause termination.
Yeah, I think Clea's point about being flexible, and also what she said earlier about documenting all of these conversations that you're having and efforts that you are making is going to be very important, because if that person were to decide to file a human rights complaint, then you will have documented the efforts that you made and the seeming intransigence of the employee, right?
And that documentation is going to include, you know, I confirm that you told me that you're not immunocompromised, you don't have an illness that makes you particularly at risk, and that you haven't identified a reason why you wouldn't be able to return, just simply that you don't feel comfortable returning. I think you would want, you know, these are conversations you may need to have orally with people because it just allows more back and forth. But at the conclusion of that conversation, you know, send them an email that says, I confirm that this is what I understood from the conversation. And then the obligation is on them to write you back and say, oh, no, I do have diabetes or whatever.
Yeah.
You know.
Yeah. And I had an interesting situation in just this week. I was talking to a client where an individual with multiple medical conditions actually was continuing to come into the office because she didn't want to work from home, as was happening pretty much across the organization. And the executive director had to insist because of her increased risk. And she was very angry about being basically told she needed to go work from home. She was the receptionist for the organization, so she had a key role. And within 3 days, she'd realized that actually she could do the job from home and was quite enjoying it. So, you know, there may be some resistance. The reason I tell the story is because there may be some resistance, and and maybe where there's goodwill, and, you know, it did take some cajoling, but she ultimately did come around to, yeah, I actually can do this part of the job from home. And the world did not collapse in her doing so. And it was safer all around for everyone. And they're going to continue to have her work from home, notwithstanding that they're going to slowly bring back other parts of the organization, other team members. It's quite a significant, large employee group, but she may not be the one who comes back. She may continue to be that person working from home.
Yeah, and it is, I mean, it's important to think about how, it's not clear to me that you have an obligation to tell an employee who's immunocompromised to stay home, or, you know, is it heightened risk? I mean, partly people sometimes have to make their own decisions about how much risk they're prepared to tolerate. And I'm not sure that, I think employers have to be a bit careful about the that's taking on that role. Unless I think the place where it becomes legitimate for them to do so is when it creates risk for others in the workplace, which might be the case, but mostly you're not more likely to get sick or be a transmitter. You're just more likely to have more serious consequences yourself. I think if you can document that you've raised your concern and you've offered them work at home, I'm not sure that you need to go that additional step of forcing them to go home.
Yeah.
And I'm not sure that you're wise to go that extra step, because I think that puts you into, you know, a place where you may.
Yeah, I don't know that it was. Yeah,
dangerous.
I think it was because I mean, in that situation, everybody was working from home. They did close the office down completely.
Yeah, and there may be other explanations for sure, but I think, you know, just taking your example to a different place, I think, just saying that it, I think it might not be ideal for an employer to get into a position of saying, you know, I know better what's good for you than you do. I think
I hear that. So another question here is, employee does not want to return to work, but I cannot keep the position vacant for him or available since the position requires to be filled immediately to provide services. And it would not be okay for the new employee to be let go when the previous employee decides to return when convenient. How to address that?
I'm addressing it with skepticism. I think it's a rare position that must be filled permanently the minute it's filled. Like most workplaces, most positions can be filled on an interim basis as necessary, and leaving open the position for the person to return to it. You'd have to make a pretty watertight case for why the position could not be filled on a temporary basis, because that is the expectation. It's a clear expectation, I think, in the case law that positions will remain open for a couple of years. You know, and less than that, I think you're going to have some real tap dancing to do to prove why it was, you know, critical for you to fill it permanently. I think you'd really need to think about temporary, and you know, we have lots of temporary placements. I mean, maternity leaves are a perfect example. Employers are required to fill maternity absences with temporary employees, and you know, the tribunal's not accepting a lot of excuses about why that didn't happen.
Yeah. One issue that arose in another conversation that we were having was the whole question of disclosure of COVID to the work group of employees. So in other words, you're back to work a month from now, and somebody's sick, takes a leave. It isn't clear whether or not they have COVID. Let's say, for the sake of argument, they have COVID. Should the employer tell the employees that this individual has COVID, or what if the person leaves? A couple of people leave, so you don't know if they have, who it is who might have COVID. What is the obligation there, and do you foresee any issues?
My guess is that employers are not going to be left to muddle through that on their own. My expectation from the various things that the provincial government has said is that there is going to be aggressive contact tracing if someone tests positive for COVID. So that means if one of your employees tests positive for COVID, they're going to be in your workplace testing everyone else in your workplace. They're going to be asking, did you have lunch with that person? So I think normally the issue that would arise, of course, is a privacy issue. I suspect that's going to be entirely obliterated by the steps the provincial health officers themselves take to contact trace that person who's come down with COVID. So I think that's going to be out of the hands of employers. I don't think they're going to have to make those decisions.
Yeah, I think it's really important that everybody here, those of you that are employers, hear that that is public health's responsibility, and the appropriate response is to say, you will be contacted by the public health officer as soon as they are on site, or whatever the protocol is, rather than taking it upon yourself to potentially breach someone's privacy without perhaps all of the facts in front of you in that moment. Very, very important.
Yes, you do have to be concerned about your employees' privacy, and you also have to be concerned about your employees' safety. But I think if someone has, you know, perhaps the more tricky situation is where someone goes home with a cough and a fever and hasn't yet received a positive test one way or the other. You know, I think if you got I think at that point you'd be dialing 811 and trying to get some input about where that person is in terms of being tested, and maybe get some input at that point about whether you should be doing, you know, trying to figure out where the contacts have been within the workplace. Because we've clearly seen with the poultry plants and the meat processing plants in Alberta that you can get an outbreak in a workplace and that can happen. And it's obviously, I think the health authorities are really, really concerned about that. So my guess is you will get pretty good uptake on that, but you know, time will tell if that's true or not. And if you're not getting uptake, then your obligation to be more proactive may be in place, and you'll have to, you know, you may have to make a decision between the individual employee's privacy and your obligation to make sure that employees who also may have been exposed to them are alerted that there's a possibility.
Right. What would you recommend if an employee returns to work but starts to develop a disability after the return? For example, they develop anxiety around contracting COVID at work or on transit.
You know, I think anxiety is clearly a disability, at least once it raises to a certain level. And if their anxiety is prohibiting them from working, then you'll be back into our same conversation about other reasons why people might not be at work. So I think, you're right. I don't think your obligation is an on-off switch. If circumstances change, someone gets diagnosed with something they didn't know they had, or if they're, you know, a disability arises, you will need to address that as that occurs.
Yeah. I think the last question we have time for may or may not be one you can answer. I don't know. My question is around benefited employees and paying for their benefits while off. Is it the employer's responsibility to continue to pay the employer and employee's contribution to the benefit providers?
That's a really specific question.
Yeah.
So the Employment Standards Act branch has some thoughts about that. They say that an employee who's off should continue to get wage or benefit increases. And it does say employers continue to make payments to benefit plans unless the employee doesn't want to continue with a plan or if they take reservist leave. And the employers continue to calculate annual vacation. So that's the Employment Standards Branch expectation for people who are taking a leave that qualifies under their understanding of leaves. And they have a new section in the Employment Standards Act, section 52.12, which talks about a COVID-related leave and essentially says you can take a leave for quite a few reasons, one of which is that you've been diagnosed with COVID, or you're following the instructions of a medical health officer or the advice of a doctor or nurse, that you are in quarantine or self-isolation because of an order of either the provincial health officer or a federal health authority, or a guideline. So if there's a guideline that suggests you should be self-isolating, then you can take a leave. That the employer has directed them not to work due to concern about their exposure to others. So actually suggesting that it is appropriate, or employers can make that direction, which a moment ago I was saying perhaps they shouldn't. They need to provide care to their minor children or a dependent adult who is their child or former foster child for a reason related to COVID, or they're outside of BC and unable to return. So those are leaves wherein it would be, I think, expected that you would continue benefits. So it's probably worth having a look at that section of the Employment Standards Act.
And we'll put up a link to that section, and you'll get an email afterwards with all these links and whatever else we cook up. There is another question that comes up and is around service provision. Is it okay to refuse to provide service to someone who is symptomatic?
Someone who's symptomatic is required to be isolating at home. And so question mark about why they would be physically requiring a service. But certainly the Human Rights Commission has suggested that you've got to be very careful about refusing services in that situation. Essentially, it wouldn't be appropriate to refuse service unless doing so unless providing the service put your staff at an unacceptable risk. So you'll have to balance your obligation to provide a service notwithstanding someone's disability, which could be COVID, and your obligation to keep your staff safe. And that's going to require you to look at the circumstances. So it's not a black and white answer.
Yeah, this would be one of those situations where, I would think if staff are prepared with personal protective equipment, depending on the nature of the service, of course, right? There's going to be a whole range of possible responses there. Rather than a blanket kind of no, it might be, it would depend a great deal on the environment of where the employer's working situation, the physical distancing, the availability of separate rooms, the availability of personal protective equipment, etc. Right.
Right, because those things are all going to be relevant to the risk that your employees are running versus your obligation to continue providing services, notwithstanding someone's disability.
So
the underlying piece of that is that you should consider COVID to be a disability. It hasn't been ruled on yet, but I think it's reasonable to imagine that someone who has COVID or is believed to have COVID is going to have protections against discrimination on the basis of disability.
Yeah. Here's an interesting, I think we're probably we got 4 minutes. Last question. If a reliable serology test is made available for testing COVID antibodies, could an absence of antibodies be considered a characteristic under BC Human Rights Code and used if employers discriminate against those without antibodies? Oh, that's a bit.
So then what you're almost positing is that being seronegative, in other words, having not been infected, is the disability. You're suggesting that if you're still at risk of infection compared to your compatriots, that you have a disability. I mean, I might construct it that way. I might make that argument. Whether the tribunal would accept it, the infection rates remain pretty low. I don't know whether I'd be able to argue that being seronegative was a disability, but if my employer is telling me I have to stay home because I'm seronegative, I guess I'm going to be arguing that's a disability. So yeah, that's interesting.
Yeah, I think that's a good spot to end, because I think that what is important to realize is that a lot of this there's so many nuances here, and there are arguments that are going to be made, and some may fly with the Human Rights Tribunal, others may not. What is most important is that you understand what your obligations are pursuant to the Human Rights Code, and feel that you can effectively manage the process, because it is going to be a process of having conversations, confirming those conversations, and then taking actions with as much support around you as possible. And that means knowing what WorkSafe says, knowing what the Employment Standards Branch is requesting or obligating us to do, as well as the Human Rights Code, and any information that we have and continue to generate over the next little while around from whether it's the Human Rights Commissioner or the Human Rights Tribunal, will be definitely posting those links. So on that note, I will thank you, Clea, for taking an hour out of your day today to share your wisdom with us, and thank everyone for participating. And that's it. Until next week, our topic is commercial rent relief with Grant Haddock. So it'll be fun.
Thanks, Martha.
Bye, everybody.